Mr. Lorentzen.
May it please the court, counsel. First, I'd like to address the constitutional issues that are raised by the Iowa's negligent empowerment statute. West Central and Westco are making a substantive due process challenge based on the 14th Amendment to the United States Constitution. My clients do not claim a fundamental right is involved. The rational basis test is what should apply. West Central and Westco do not challenge the legislature's legitimate interest in the regulation. And because the presumption that's raised by the statute is rebuttable, the threshold issue is whether the presumption is arbitrary. If it is arbitrary, there is a secondary issue, whether it is severable. The court's standard of review is de novo. To establish a statutory violation, a plaintiff is only required to prove two elements. First, that specified unlawful activity occurred. Second, that it was facilitated by the defendant's property or services. Proof of a violation does not require any evidence of negligence or wrongdoing. In Hensler, this court made clear that as a matter of law, the court does not permit a fact finder to presume a person's negligence merely because some incident occurred. It would be arbitrary and irrational. It would be unconstitutional. Nevertheless, once the plaintiff proves the statutory violation, the district court, and I'm quoting from Section 3, shall grant relief. Upon proof of a violation, plaintiff's damages shall include all reasonably foreseeable damages proximately caused by the specified unlawful activity. Now, at this stage of the process, damages are not limited to those proximately caused by either the defendant's negligence or wrongful conduct. Rather, the defendant is presumed to have liability for all damages that are caused by the specified unlawful activity committed by a third person. The statute then places the burden of proof to prove by a preponderance of the evidence as to the circumstances constituting lack of negligence and the exceptions to the limitations on liability.
I think you're raising some pretty good points on the questionability of the presumption based just on the limited circumstances described in the statute. But severability, why can't we just strike, if assuming we found it an unconstitutional provision, why couldn't we just strike B4 and then under the plain language of the statute, there is a negligence requirement, and it would be up to the plaintiff to prove negligence. Doesn't that solve it?
No, it wouldn't, because first of all, subsection B, which has to do with damages, the first three numbered subsections there, those are all premised on the fact that there is a statutory presumption and that the burden is on the defendant then to prove these conditions which would limit the defendant's liability to the defendant's own conduct or to something less than all the damages that are caused by specified unlawful activity. The second reason is that if you just strike all of subsection B, then
just B4.
No. What I'm suggesting here is that because the damages section, which includes B as well as the numbered sections 1 through 4, they are a reticulated law which requires the presumption in order for it to make any sense or to operate. And then what I'm suggesting is that if you strike subsection B, which I think is required, then the issue that remains is whether subsection A should remain. And here is the objection to leaving subsection A. When the legislature created this civil wrong called negligent empowerment, it created a violation that did not exist at common law. It was made up of certain elements. It had burden shifting, and if the court eliminates those components of the civil wrong which the legislator created and was like no tort that had been recognized before, then the court would have to develop whatever the elements were for that tort. Which
They're in there. It says, it is unlawful for a person to negligently allow property owned or controlled by the person or services provided by the person. So what do we have to develop? There's the words in there.
the word negligently is in there, but just because that was in there doesn't mean that's what the legislator meant. In other words, that it meant common law negligence. Clearly, the legislature did not mean common law negligence. Clearly, the legislator created a civil wrong that didn't exist before and has the elements that require the presumption in subsection 4. And so if the court removes the elements for which the legislature created that civil wrong, then you would be essentially legislating a new civil wrong that the legislature did not create. The other objection to retaining subsection A is there's a remedies section, which is, the negligent empowerment statute is in section 2. In section 3, there's a remedies section, and includes treble damages and attorney's fees, which have their own burden shifting. In other words, if subsection A remains, there is still going to remain a burden shifting problem where the defendant is going to have to exculpate himself from liability for what is essentially punitive damages for negligent conduct and prove non-liability. And that is also at least in the negligent context, that is also an unconstitutional burden shifting. If you remove all of the negligent empowerment statute, declare it unconstitutional, the legislative purpose behind the rest of the act makes sense, not only in terms of what's required for violations, but what's required for the remedies that are allowed. And after all, this is a statute that's patterned after RICO, and RICO does not have any kind of corresponding negligent empowerment section. And yet, RICO, I believe, has as its purpose what could be the remaining appropriate legislative purpose of 706A without negligent empowerment. I would next like to address the inconsistent verdicts unless there are more questions about.
You know, Hensler involved parent-child relationship. Is the employer-employee relationship different in a way that we should disregard Hensler?
I don't think so. And what's critical about the relationship in Hensler is the same that's critical about the relationship in an employer-employee relationship, and that is the evidence that's necessary to prove negligence actually involves a complex series of facts that have to do with accounting and auditing as well as oversight. In fact, arguably would require expert testimony in order to determine whether a standard had been breached, a standard of care had been breached.
The statute doesn't require employer-employee relationship. Anybody who supplies property or services that ends up being used for an unspecified or, specified criminal activity is in jeopardy, right?
That is true. But then you get back to the cornerstone of Hensler, and that is it is unconstitutional to presume negligence or liability simply based on an incident that's happened. And that's the core principle that you can't escape with this statute. It is the same kind of a statute that the U.S. Supreme Court declared was unconstitutional in Western and Atlantic Railroad in 1929, and essentially it's the same kind of a problem that was in Hensler. It's actually a more difficult problem than Hensler because Hensler was a second violation that gave rise to the presumption. And here, any defendant is at jeopardy for the first violation. And the presumption should be, in fact, subject to greater scrutiny, not in terms of a legal test, but more difficult to achieve constitutionality. Are there any other questions about the statute? Next, I'd like to address the inconsistent verdicts. The verdicts are inconsistent. The Court of Appeals acknowledged, at least in the words of appearance, that they were. The real issue here is how far may a court go in trying to reconcile inconsistent verdicts. This is a legal issue. The standard of review is de novo.
Here's where I want you to focus, at least me personally, on the inconsistent verdicts. I understand that on its face it's somewhat inconsistent that the jury finds Hartzler engaged in commercial bribery and the Wollesens didn't. But there's that instruction 29 that seems to say that you can't tell the jury you can't find for the co-op on the ongoing unlawful conduct if, in fact, you find that they were sort of in peri delicto, that they knew what was going on or should have known what was going on as much as the Wollesens did. And why couldn't the jury have relied on that and said, well, there's in peri delicto, therefore we're not going to find in favor of the co-op and against the Wollesens, but we'll find in favor of the co-op and against Hartzler?
The first reason is that that ground was not urged in the district court by the Wollesens or Isle Plains Farms, and this court may only affirm on a ground that was. The second reason is that in peri delicto is a defense. In other words, it is not an element.
You moved for a new trial based on inconsistent verdicts. The district court denied the motion, right?
Correct.
Now, why can't they get up here and say that advance any number of reasons why the verdicts weren't inconsistent? Are they limited to what they argue below? They're not the appellant on this issue.
This isn't a question of preservation of error. This is a different rule that the court has adopted, which is that a district court judgment may be affirmed for any reason that was urged in the district court. It have to be the reason that the district court relied on. We actually don't know what reason the district court relied on. But the Wollesens and Isle Plains Farms did not argue the in peri delicto instruction in their in resisting our motion for a new trial. And so this court may not affirm for that reason. The second problem with in peri delicto is that it is an affirmative defense. In other words, it is not an element of a 706A claim. And it has nothing to do with the marshalling instruction or following the instructions. If in fact, the jury found that Hartzler committed commercial bribery, then they would have to find that one of the defendants did as well. But they would have to make that finding before they would reach the in peri delicto defense. In other words, the in peri delicto defense means nothing until there's a finding of commercial bribery.
I understand that. That's a logical way how lawyers like you and I might view it, but the instructions are the law of the case, and as I read the instructions, it seems to me a jury could easily have just sort of hung their hat on instruction 29 and said, no liability for the Wollesens for ongoing unlawful conduct.
Actually, if the jury had not found that there had been commercial bribery, then the jury would have had to have gone no further than question number 1 on the jury form, which reads, did Chad Hartzler violate his duties to his employer? And certainly if they had found that there was some crime involved other than the crime that was the predicate act in a 706A claim, which was commercial bribery, if they had found that there was some other criminal act, federal wire fraud, or theft, or whatever it might be, they could have answered yes to question number 1 and no to question number 3. And in fact, they did answer yes to question number 1, and the reason that we're here on this particular point is they didn't stop. They went on to question number 3 and said, yes, we find Chad Hartzler committed ongoing criminal conduct by commercial bribery. And that's the inconsistency. They had to work through the marshalling instruction, and they could not simply ignore the requirements of commercial bribery. I mean, what you're assuming is they didn't follow the instructions, and of course that's one thing this court cannot do. They cannot assume that the jury didn't follow the instructions or found that there was some other law. In other words, they replaced the job of the judge as the determiner of the law, which they cannot do, and concluded that there was some other wrong that had happened. The court simply can't go that far in trying to reconcile a jury verdict. I believe my time is up.
You may sum up.
Thank you. I will do that during my reply.
Mr. Lorentzen, thank you. Mr. Voss.
May it please the court, opposing counsel. Like opposing counsel, I will start with the 706A.2 subsection 5 claim. And we agree in several significant respects with them that no fundamental right is implicated. And so the question is whether this is a rational, there was a rational basis for the legislature doing what it did when it created the burden shifting in subsection 4. But I think Justice Mansfield asked the right question, which is why can't we, if you will, use a scalpel rather than a chainsaw if there is an infirmity with section B4 and simply excise the shifting of the burden of proof of lack of negligence and then apply the rest of the statute the way that it is written. And the answer is there is no reason why this court would be unable to.
I'm somewhat confused here. A violation of a statute is normally negligence per se. Is that correct?
That's correct, Your Honor.
In Hensler, we didn't have a violation of a statute. We had certain conduct was labeled as negligence per se. So once a defendant, once the plaintiff proves a statute's violated, which under our law is negligence, I mean, what's wrong with shifting the burden over to the defendant to show it wasn't negligence? Normally, if it's negligence per se, you have to have a legal excuse or something to avoid the problem.
I certainly believe that it is typically the legislature's prerogative to define the elements of a cause of action if they're choosing to do so. And they chose here to shift the burden of proof to the defendants, and we will agree that the court actually, that the statute actually does that. So we disagreed with the Court of Appeals analysis. But if you go to the Court of Appeals opinion, they dropped that footnote to say we shifted the burden here because the defendant is going to be the one who has peculiar knowledge of their.
But here's the problem I have on the presumption side. I mean, I agree there's a violation of the statute, but it was by, it wasn't by the party that you're shifting the burden against. It was by another party. And it strikes me that this is a very, very broad statute, this negligent empowerment, and could be actually applied to parents, kind of like Hensler. I mean, one thought that occurred to me is if I buy, let's say, or rent an apartment or a condo for one of my kids while they're going to college and some illegal activity occurs in that condo or apartment, the burden would then shift to me to prove that I was free from negligence, wouldn't it, under that statute?
Under that statute, potentially yes, Your Honor, because the question is whether the person against whom liability is sought to impose did negligently empower the activity to take place.
Uses this broad word empowerment, but really all you have to do is supply property or services, right?
It has to facilitate unlawful activity. And so that, that's the statutory language that we did not get the opportunity to try and prove, and that they did not end up disproving because it was.
Does any other jurisdiction have this statute? I'm guessing you folks, during the course of this lengthy litigation, looked at this. Does any other jurisdiction have this ongoing unlawful conduct statute or something like it?
Your Honor, that is a fair question, and I think I knew the answer to it at one point, but I can't tell you now. I will say if it was adopted, it's not been widely adopted in many other jurisdictions, and so my attempt in terms of briefing this to look for places where it had been applied was unsuccessful. So I can't tell you that it's 5 or 3, but to go back then to Justice Zeiger's question in terms of, or sorry, Justice Waterman's question as to does the parent-child dynamic in Hensler make a difference compared to the scenario here? I think there is an obvious difference between the two. That is, when you are an employer, you have one obvious ability to control employees that is not present to parents. You can fire employees, and that's not something that you could do in Hensler with children. They're yours for good or for bad, and so I think this court should reject the implication that there's somehow a difficulty inherent in this relationship that's equal to or greater than the relationship that there exists between parents and children, because you do presume that an employer has the ability to control the actions of their employees. And if we go and take a look at one of the difficulties of the language of Hensler is that Hensler says very broadly that we sort of we categorically presume that, or refuse to presume that negligence occurs just from the fact of an incident. But there are plenty of places in Iowa law where we recognize presumptions of negligence. And, you know, so the Cady case dealing in the work comps area is one of those cases where there's a presumption of negligence if you have an employee who's injured on the workplace and the employer did not have workers' compensation insurance. There's a presumption that for more than 70 years has been considered constitutional. And so it's not as though all presumptions are unconstitutional. Some are. Hensler was, some are not. Jacobsma finds that the presumption that was there was not irrational. If you look at the Calkins and the Adams cases, that gives you a pair of cases construing the same statute to say when is a presumption irrational versus when is it not irrational. And so in Calkins, that presumption was irrational as applied in that case because the electric utility in question, all they had done was place a guy wire and the horse trips over it and the plaintiff's injured. The court says, not surprisingly, well, that's not related to transmission of electricity. We're not going to find the statute shifting presumption to be constitutional there. But you get to Adams, and instead of a horse tripping over a guy wire, you have a person who's electrocuted. And the court says, well, this is related to transmission of electricity. This is a place where the presumption can constitutionally be applied. And so the question is just, it comes down to, is there a rational relationship between the statutory evil that they're trying to address and the means that they've chosen to do it? And that's where I get back to the footnote, if you will, from the drafters of the Uniform Act saying, we're shifting the burden of proof here because the defendant is the one who's in possession of the knowledge of what their procedures are. They are the ones who are able to rebut this if there was.
Except that's opposite the way we normally do negligence cases. And I understand the idea of shifting the burden if it's sort of a narrow situation. You have a narrow category of proof that you probably have in your possession as the defendant. But here you're talking about activity that went on over years and years. And when you put somebody in the position of having to show that they exercise due care, you know, to sort of prove a negative that way, that can be quite a burden, right?
I'm not denying that it can be a burden. The question is whether it's an unconstitutional burden, and I think here they still are the ones who are in possession of knowledge of what their procedures are, whether those procedures were followed. If they weren't, that's what creates the risk.
If we affirm the district court's ruling that this burden shifting is unconstitutional, would that cast a cloud over the work comps burden shifting?
I think that the rationale that would be adopted would definitely cast a cloud over it, because you have, at least in this circumstance, both of them are employer, situations, and so it's hard to say that the work comp presumption is fine when in this scenario, and there's a difficulty here that this is a facial challenge, and so it's in some ways harder for this court to write a narrow decision, because you're saying this statute is unconstitutional as applied to any situation, and so I think since it is a facial challenge, that makes it even harder for this court to say that everything's fine with other presumptions after it would rule on this, Your Honor. If I may shift to the question of whether the verdict was inconsistent, I do want to correct one thing, and that's when we look at the language of the jury interrogatories. Question number 3 was, did Westco prove that Chad Hartzler engaged in ongoing unlawful conduct? There's no reference to bribery in question 3. Then question 4 was the one that asked the jury to place an X next to each way that Chad Hartzler engaged in ongoing unlawful conduct. And that's where the jury did not say that he had committed commercial bribery for financial gain on a continuing basis, and the jury did not say that he had knowingly received any proceeds of commercial bribery for financial gain on a continuing basis. So there was never a finding that any of these parties were engaged in commercial bribery. And so
They overlooked the boxes, and apparently everyone did at the time, right? But
well, you're asking me to assume that they overlooked the boxes rather than intentionally saying it wasn't either of those.
weren't instructed on any other alternative. Those were the only two.
They were, in instruction 18, they were instructed on the elements of ongoing criminal conduct, and 18 subsection 6 gave them the generic definition of specified unlawful conduct. And that's what the Court of Appeals hung their hat on in saying there's no inconsistency, is that the Court of Appeals presumed that you read the instructions as a whole, and when you look at the whole, they were given a definition of specified unlawful conduct that said that it applied to all of the ongoing criminal conduct instructions. And so that's the way in which it could have been reconciled. But you had also asked about the in pari delicto defense, and just to clarify, that is indeed part of the statute. when you go forward to Iowa Code 706A.3, subsection 7 is the one that has the treble damages language in it, but it says that a person who's been injured may bring a civil action, and then it says subject to the in pari delicto defense. And so by statute, the in pari delicto defense was incorporated. That's why the instruction was given, and I think your question was perfectly on point, that the jury could have found that the Wollesens were not responsible for committing, or even if they had found commercial bribery, they could have applied the in pari delicto defense and said, we're going to find West Central had equal or greater knowledge, and we're just going to leave them where we found them, essentially, Your Honor. So that was certainly something that it would be an unusual error preservation rule that says that a jury instruction that was given cannot be relied upon as a basis for affirming. And so while the Court of Appeals didn't reach it, this court would certainly be entitled to reach that defense as alternative grounds for affirming the jury's verdict. I see that my time is up. Thank you, Your Honor.
Mr. Voss, thank you as well. Mr. Lorenzen.
Begin by answering Justice Wiggins' question, which is this like negligence per se? The answer to that is no, for two reasons. One is that of the negligence per se statutes of which I'm aware, the Motor Vehicle Code is the classic example. The plaintiff still needs to prove proximate cause. In this case, once the two elements of the violation are shown, then the presumption is stepped up to include all damages proximately caused by the specified unlawful activity, not just damages proximately caused by the defendant's conduct. So there is a presumption of causation here which is unconstitutional. In addition, this statute does not establish a defendant's standard of conduct like a driver can't exceed the speed limit. The statutory violation is triggered rather by somebody else's conduct. In answer to Justice Mansfield's question, as of last week, no other jurisdiction has adopted this model act other than Iowa. And to address Justice Waterman's question about workers' compensation, if this statute is held unconstitutional, it will have absolutely no effect on workers' compensation. I believe that the correct justification for the presumption of negligence is consent and waiver. An employer in workers' compensation has the choice to buy or not to buy workers' compensation insurance. Due process is a personal right that can be waived. In terms of the extent to which this statute could be saved, which I do not believe it can, if you simply allow subsection A to stand, then you would be assuming, you would actually be speculating that the legislature would have passed this statute if only traditional tort elements of negligence applied. And there's nothing whatsoever to show that that's true. I happen to think that Justice Wiggins observed that if the statute is unconstitutional because the elements aren't shown, they can pass a new statute next year. They can show what the elements are. This is completely different than Hensler, where what you did was you held the second offense elements unconstitutional, and what was left was what the legislature had passed to show a first offense. And so there's nothing, absolutely nothing inconsistent with doing that and Hensler and declaring all of subsection 5 unconstitutional here. An additional reason that I didn't quite get to about why the in peri delicto defense is not a ground to reconcile the inconsistent verdict, is because, as a matter of law, there was insufficient evidence that West Central or Westco would have been in peri delicto with any of the defendants. And the reason why is that there are two things that the defendants knew and that Westco and West Central absolutely did not know. And that is, the defendants were paying Chad Hartzler money in connection with these deals. That's number one. And the other thing is that the Wollesens were, based on the presumption of mailing and receipt which we established, the Wollesens were receiving these statements. They knew, even though West Central didn't know.
And I agree, if I'd been on the jury, I might have had a problem with that testimony about the statements, but they denied, with very few exceptions, having ever received those statements. And isn't that enough to make it a jury issue?
No, I don't believe it is. I believe that if the jury and this court on review can find as a matter of law that the Wollesens received them all because the presumption was proven. In other words, the predicate facts were shown to trigger the presumption. And the Wollesens and Iowa Plains Farms did not rebut the fact that they received them, other than to deny that they received them. And that, as a matter of law, this court should hold, is insufficient grounds to rebut the presumption. So I think, on review, you can assume they received them. They knew there were two sets of books. West Central and Westco did not. Finally, I see that my time is about up. I have not been able to address the equity trial, but I would request that you review the arguments that we've made in our briefs about that. Thank you very much.
Mr. Lorenzen, thank you as well. The case of Westco versus Wollesen is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.